Dear students, let us study something about product liability. As per the dictionary meaning, it is the legal liability a manufacturer or trade incurs for producing or selling a faulty product. Product liability is the area of law in which manufacturers, distributors, suppliers, retailers, and others who make products available to the public are held responsible for the injuries those products cause. There are three types of product defects that can result in product liability cases. The first one is design defects. Design defects present in a product from the beginning, even before it is manufactured. In that, something in the design of the product is inherently unsafe. Manufacturing defects are those that occur in the course of product manufacture or assembly. The third one is marketing defects. Flaws in the way of product is marketed, such as improper labeling, insufficient instructions, or inadequate safety warnings. Let us discuss in detail. The first one, that is design defects. Design defect cases focus on flaws and errors in a product's design that make it unreasonably dangerous to the consumers. If a product has design defects, all the products of the same type have the same defect. It is in contrast to a manufacturing defect, which is created once or up to a few times during the production of a batch. Unlike other types of product liability cases, which can be brought against a seller or assembler, a design defect case is usually only brought against the manufacturer responsible for the design of the product at issue. The second one is manufacturing defects. Unlike design defects, manufacturing defects usually exist in one or few items rather than every product in a line. There are aspects of the products that the manufacturer did not design or intended. Instead, they occur when a product deviates from its intended design, regardless of how much care the manufacturer took to design the product, select the material, and oversee its production. A manufacturing defect occurs during the construction phase of a product. For example, an airbag that lacks proper mechanism to deploy probably has a manufacturing defect. Similarly, a bottle of cough syrup that is contaminated probably has manufacturing defect. Any manufacturing defect that causes an injury can give rise to a product liability lawsuits. Generally, manufacturing and quality assurance control limit the number of defective products that are shipped to the consumers. However, occasionally a badly manufactured product bypasses the systems that are in place to make sure that it is not defective. The two most common defects involve low quality materials and poor workmanship. While assembling components to make the product finished, often the manufacturing defect could be eliminated if a more careful worker or better quality materials were used to create the product. If an injury producing problem would still be there, whenever or not the product was put together well. The issue is probably a design defect rather than manufacturing defect. When a badly manufactured product leaves the manufacturer and causes injury, when used for its intended purpose, the manufacturer is liable for any injuries that result under the principle of strict liability. The third main type is marketing defects. Marketing defect can be the basis of a product liability lawsuit when a manufacturer or seller does not warn a consumer about dangerous characteristics of a particular product. A product can be defective even if a particular product does not meet any legal definition of being defective, because a design defect or manufacturing defect, an injured person can establish the existence of a marketing defect by providing a risk of harm may arise from either producer's intended use or reasonably anticipated use. What must be shown to the marketing defect is knowledge of a foreseeability of a risk of by the product seller at the time the product is marketed, lack of warning or instructions that make the product consumers, and link between the failures to warn and product users' injury. Strict product liability is the theory that a distributor, seller, or manufacturer is liable for a defective product, regardless of the plaintiff's fault. It does not matter whether the seller, distributor, or manufacturer of the product reasonable steps to ensure the product was not defective. Strict liability is the imposition of a liability without fault for damages on the dependent. This is different from the negligence, as the burden of proof is not placed on the plaintiff to prove that the damages were a result of the dependent's negligence. Only that damages occurred and the defendant is responsible. Product liability claims can be based on negligence, strict liability, or breach of warranty of the fitness, depending on the jurisdiction within which claim is based. Thank you.